Welcome to another edition of Better Informed Housing. My name is Carl Dreyer, and I'm hosting the October edition of Better Informed Housing. Better Informed Housing Corporation has devoted its energy to passionately educating and informing communities on their real estate rights. Many of the communities are politically underrepresented members of our city. The city of Chicago has over 100,000 vacant properties. These zombie properties attract crime, invite danger, drive down neighborhood values, and push out local families. Better Informed Housing seeks to change that. You can check out our website here. If you have any questions, please call in tonight, and we'll be happy to answer your question to the best of our ability. Tonight, we're going to be discussing legal malpractice in reference to housing matters. Now, when individuals get involved with purchasing or selling houses, often they know that it's important to hire a lawyer. Also, if they're faced with a foreclosure of their house or an eviction of the rental property they're in, they should also seek a lawyer. However, lawyers screw up, and that has been known to happen every once in a while. And therefore, it's important for everyone to know that when they hire a lawyer and get into an attorney-client relationship with them, they need to make sure that their lawyer doesn't cause any injury to them. Now, a legal malpractice claim is something that a client will find happens if, say, they're going through a foreclosure and the lawyer was supposed to present a motion to get a continuance of time to present a sale of their property which is in foreclosure, because the client already has a signed agreement with a buyer to do a short sale, which if the short sale goes through, then the bank won't go after them for any shortfall. Well, let's say the lawyer prepares that motion and then the lawyer doesn't go to court on that motion. The judge then enters an order saying that the sale goes forward and the sheriff's sale goes forward instead of the short sale that was supposed to go forward. And as a result, now the client is facing a $200,000 judgment shortfall. Well, the first thing that a client needs to look at is, did my lawyer cause this to happen? And if your lawyer did cause this to happen, then it's important that you seek out a legal malpractice attorney. And I've had 15 years of experience in dealing with legal malpractice cases. And I have clients come to me all the time with issues about what they think their lawyer did wrong. But of course, you need to look at what your lawyer did wrong. First, you need to find out, did the lawyer cause actual damages? If the lawyer was somebody that, say, you didn't like and they really were nasty to you, that's not grounds for legal malpractice, although it could be grounds for going to the ARDC disciplinary commission if they were acting in an unethical manner. Now, legal malpractice is a separate cause of action that is brought separate to your case that you could have had in foreclosure, or separate to your contract that could have resulted in a breach of contract. Now, when some of the things you need to look at is, did the lawyer cause the damage? So if you were looking to purchase a house and you put money down on that house and suddenly the contract falls apart, well, one thing you need to consider is, was it your lawyer that caused the contract to fall apart? Did the lawyer fail to provide the necessary documents within the times that are necessary for the contract to go forward? Or did the lawyer just blow those dates, and the next thing you know, you've got a breach of contract claim against you, which resulted in you losing your down payment? Now, when you look at the loss that you had, you need to make sure that it's a monetary loss, because a legal malpractice claim requires Number one, that the attorney that was representing you owed you duties of care in the work that they were performing for you as part of the attorney-client relationship. And number two, that they breached one or more of those duties. And number three, that their breach of the duty proximately caused the injury to you, the client. Now, as I said before, it has to be an actual damage. And one of the reasons that that's important is because damages usually don't occur until there's an entry of a judgment or there is a loss of a contractual deal where you were supposed to get something and now you can't get it, such as in purchasing a house. Now, one of the things that is important to bring to a lawyer such as myself is all of the information that you have. Because when I get a claim for legal malpractice from a client, the first thing I do is try and get as much information as possible from my potential client to see what the lawyer should have done or what the lawyer failed to do. And if they took a certain action or failed to take a certain action that proximately resulted in your damage, then there's a good basis for looking into bringing a legal malpractice claim. And that is something that takes a long time. And the reason why it takes a long time is because in a legal malpractice claim, you have to prove the case within the case. And in proving the case within the case, you have to present the evidence from the underlying matter or the underlying transaction and provide both witness testimony and expert testimony that shows that you would have likely prevailed had the lawyer not committed the negligent acts or omissions of legal malpractice. And that, of course, has to go through the legal system. And if you're in Cook County, it could easily take in excess of 2 years. Another thing that's important to consider is whether or not the lawyer that you're considering of bringing the legal malpractice action against has insurance. Now, if they don't have insurance, it could be difficult to collect on a judgment that you might get from the legal malpractice claim. And the reason why it might be difficult is because, number one, lawyers are very good at hiding money. Now, besides that, a lawyer also would know that if they're going to have a $200,000, $300,000 judgment against them, one of the quickest things they could do is file for a bankruptcy. And if they do that, you're going to have to take your judgment and file a new claim in the bankruptcy court. And if they have all kinds of other creditors out there who are seeking to collect, and they have a priority over you, you might not even be able to recover anything. That's why it's also important that when you go seek a lawyer such as myself with regards to a legal malpractice claim, you should find out if that lawyer that you're seeking to bring the claim against has insurance. Because if they do, you're more likely to get a settlement out of that case. Now, in my experience, the insurance companies typically wait until either the day of trial or even just before the jury is called out before they decide, hey, we're going to put some real money on the table. And the reason that they do that is because, of course, they want to see that I, as a plaintiff's attorney in a legal malpractice claim, have provided the necessary evidence to prove the case within the case and to have the experts to show, including a legal malpractice expert, to show that what the lawyer did was wrong and that any opinion evidence that was required in the underlying case could be proven. Now, you don't have to, of course, prove it to 100%, but it has to show that it would have been likely that you would have prevailed had the lawyer not committed the legal malpractice. And it's important to make sure that you stay in communication with your lawyer when you are going through a foreclosure action and when you're going through any kind of transaction to either purchase or sell a house. Now, if your lawyer is not responding to you, of course, that could be a red flag that they may have committed legal malpractice, but it doesn't necessarily mean they have. What's important is that you go to a lawyer such as myself, to present the evidence so that I can do a detailed analysis to see if there has been any kind of wrong done by an attorney that would amount to such a claim for legal malpractice. Now, there is something out there that's known as a strategic decision by a lawyer. So if a judge decides against your case and you find out, well, there could have been some better case law or a better argument that the lawyer could have made, but just merely stating that a lawyer could have made a better argument doesn't necessarily mean that they committed legal malpractice. But if there was a necessary witness that had to testify, and that lawyer didn't provide them when they could have provided such a witness to prove up your case, that could be grounds for legal malpractice. So, in terms of deciding whether or not to proceed, it's important to find out if something goes wrong in my case, I need to see what caused it to go wrong. And if I can find that it was my attorney that was a proximate cause, not necessarily the only cause, but a proximate cause of the damage, the actual damage that resulted, then that indicates that there could be a good claim for legal malpractice against the attorney that was representing you. And I don't see that there are any callers tonight. If there are, now would be a good opportunity to call since we only have a few minutes left. But I would like to inform you that Better Informed Housing has devoted its energy to passionately educating and informing communities on their real estate rights. Many of the communities are politically underrepresented members of our city. And you can contact us at neighbors@betterinformed.org, and our website, as you can see here, is http://www.betterinformed.org/contact-us.html. And once again, I would like to thank you for tuning in tonight. My name is Carl Dreyer, and I thank you for listening to another edition of Better Informed Housing. We hope you enjoyed this October issue of Better Informed Housing, and we hope that you have a good evening. And again, please make sure that if you find out that a lawyer has caused something to happen to your case, remember that it's important to find out from a lawyer, such as myself, if it's the lawyer that caused your case to result in a judgment against you, or if it was your lawyer that caused the transaction to fall apart. And I thank you very much for your time tonight.